Anand?
Yeah. It is a warm evening here in India. Good evening to all. On behalf of CNICA, I am privileged to welcome all the participants for today's study series. The zeal and enthusiasm of the participants to the study series has been a constant source of support and motivation for CNICA to conduct the study series. It has been Cineca's endeavor to popularize and to promote the ADR practices right from its inception. Cineca was formed in the year 2004 under the Aegis of Trust for Alternate Dispute Resolution with a non-profit motive to serve the society at large and to resolve the legal disputes by providing ADR services. Cineca's Mediation Center was inaugurated in the year 2006. Cineca has its panel of arbitrators, and apart from being appointing authority in its institutional arbitration, Cineca provides venue for ad hoc arbitration, conciliation, mediation through its state-of-art venues. With an influx of foreign investment, overseas commercial transactions, and open-ended economic policies acting as a catalyst, international commercial disputes involving India are steadily rising. This has drawn tremendous focus from international community on India's international arbitration regime. Today's topic to the study series, prominent cases of India-related international arbitration, thus has a very great significance. We have with us today an illustrious son of the soil and a person who has conquered the hearts of the conqueror, Sri Saroj Jaiwala. He will be taking us through the intellectual journey of prominent cases of India-related international arbitration. May I request the chairperson, Sri D. Saravanan, to welcome today's speaker. Saravanan, over to you.
Yes, thank you. Thank you, Mr. Anand. Thank you, Mr. Ashokapadi. So the participants for today's event is from the various parts of the world. Therefore, my good morning, good afternoon, and good evening. Today's speaker on the topic is Mr. Saroj Jaiwala from London. Mr. Saroj Jaiwala needs no introduction, but it is my honor bound to introduce his adventures in English courts to this august gathering. In 1975, a young lawyer who studied in Government Law College, Bombay, took the cheapest flight to London with youthful enthusiasm. He began his practice in shipping arbitration, working primarily for the Indian government. He is widely regarded as a trailblazer in litigation and arbitration, having changed the law in over 115 commercial cases in the United Kingdom. Now, he is a successful Indian lawyer in a foreign land. He was the first Indian to start an English firm of solicitors in the city of London, and now the Jaiwala & Co. is a groundbreaking law firm in London. In 2019, Mr. Saroj and his firm successfully settled a 9-year, 1.3 billion claim brought by his client Iran's Bank Mellet against the United Kingdom government for the wrongful imposition of sanctions against the bank. This was the highest value claim ever brought in the UK for such a sanctions case. Mr. Saroj Jaiwala has walked the corridors of power and rubbed the shoulders with ministers, diplomats, industrialists, and celebrities. Over the years, Mr. Saroj has amazed a phenomenal global client list of industry, governments, high-profile individuals in public life, and celebrities in entertainment and sport. He has even been called upon by the Dalai Lama to facilitate a dialogue with China over Tibet. He is a former member of the International Court of Arbitration of the ICC Paris in the year 1990. In 2002, the Indian Prime Minister awarded him for his outstanding contribution to the field of international arbitration law. Mr. Saroj is ever resourceful, ingenious, and charming personality. Cineca is very happy to welcome you, sir, and I request you to take the digital dais. Thank you, sir.
Mr. Saravanan, thank you very much for this introduction. A lot of which I think is unnecessary, and I've always considered myself as a very ordinary person. You know, Voltaire, the French philosopher, said that the greatness of a great mind lies in its humility. And the more humble you are, the more divinity flows through you. So what I'm going to do today is to share my experience with you over the last 38 years of international arbitration. I'm going to take you through some international experiences of non-Indian government arbitration also, including my experience acting for Chinese government, where I had an office for many, many years. So I'm going to start by thanking everybody and all the participants. I'm going to go on for about 45 minutes, 30 to 45 minutes, and I'll be free to answer any question. I don't know whether you know, but yesterday, my firm and I was in the news all over the world. And I say this as a proud Indian. And that was because day before yesterday, my firm filed a claim of 1.6 billion euros against Bank of England on behalf of the Central Bank of Venezuela, who wanted back their gold which they had given to Bank of England for safekeeping. And the only reason I say this, that people come to us for difficult cases, and I'm very proud that I maintained my Indian name and I did not anglicize it. And that is something why I mentioned this. And this is a worldwide news. And yesterday I was in the Euronews and CNN on an interview. And I think every Indian can do that, and but with honesty and integrity. Now I'm going to start on how I started. I joined the firm and I was fortunate to get training contract in a firm which was doing maritime arbitration. And I met a very eminent international, probably all-time well-known arbitration, Cedric Barclay. And Cedric Barclay told me, he says, Sarosh, you're good. If you join one of those big firms, they'll take you. But every year, this partner will take you for lunch and put you, and say, good job, old boy, and you will remain where you are. But the people around you will go further and you will not. So he encouraged me to start, and I'm grateful to him, Cedric Barclay, to do so. My first ever arbitration was the Dubai company, Global Shipping Company, which was part of the Al Shirawi Group. And that was relating to a ship contract to carriage of goods and material for construction of Jumeirah Beach Hotel in Dubai. This was way back in 1982. And just to give you an example how informal the arbitrations were in those days, I was acting for a claimant who had a big claim, millions of dollars claim against the contractor, Arabian Development Corporation, who had the headquarters in New Orleans, United States. And the defendant applied to the arbitrator to shift the venue to New Orleans. And my client and I said, no, this is London arbitration, you can't shift it. But Cedric Barclay, the arbitrator, said, let's have a meeting. And when we all sat down, this is an example of informality. We said, before any of you speak, he gave us an account how economical it would be to hold the arbitration in New Orleans. And so we moved to New Orleans, and it was one of the most fascinating arbitration which I'd handled. And on the flight, in a first class cabin, I was on my own, and the other side's team was there. And guess who was on the flight with me? Tony Blair. He was a junior counsel for the ADC team. And his senior, who later on became his Lord Chancellor, half drunk. And he actually apologized for being drunk. And I was introduced to Tony Blair. But we stayed for 2 weeks arbitration. And the sole arbitrator made it a rule that every 6 o'clock, all of us must meet in the bar for 45 minutes, whether you like it or not. And that was the spirit how the arbitrations were conducted when I started.
Ashok, voice mute item.
Sorry? A revolver around him. And I had to apply to the arbitrator that he must remove his revolver, and the arbitrator made an order that he should leave the arbitration room, deposit his revolver, and come. I now come to my involvement with India. I started the firm in an Indian name, and I insisted on calling my Indian name. And that time the High Commissioner was Dr. Saeed Mahmud, who was, if you remember, he was the Advocate General of Kerala. And then during Mrs. Gandhi's emergency, he was the Minister for State for Law. So I was a non-practicing barrister, was the High Commissioner. And he saw a young Indian Parsi boy starting a small firm. He invited me for a cup of tea. And believe it or not, but without knowing anyone in Delhi or any contact in Delhi, he appointed me as the High Commission Solicitors. And that was one of the greatest experience, because at that time, India was going through a big famine. And President Johnson had donated free aid in the PL 480. That means the wheat was given free. Millions of tons of wheat was given free, but India had to charter ships. And India would charter about 250 ships a year, and every ship had some dispute or the other. So that was a great experience. One of the first classic case which I handled for India was concerning a vessel called the La Pintada. And the issue was whether if the government, if the charterer has late payment of debt, is he responsible for compound interest? And there was a judgment of Lord Denning, who was a very great equity judge, and he said, oh, if the debtor pays his debt late, he has kept the creditor out of the money, so he must pay compound interest. Now that meant that India would have to face liability for about $5 million. So as a test case, we took it to the arbitration. We lost. I appeared myself, we lost. And in the High Court, the judge referred it back to the arbitrator, who confirmed the same award. And ultimately, we won in the House of Lords. And that was the first ever Indian case in which went to the House of Lords, and we were successful. I'm now going to turn to some of the classic Indian case and the court supervision of it. And one of the first cases which come to mind was years ago when Ashok Sen, who was the Law Minister of Justice and the three Prime Minister, Pandit Nehru, Indira Gandhi, and Shastri. He had appeared in an arbitration for Steel Authority of India against a company called Heim Metals. And there was an award of about $18 million. And he was very dissatisfied. So we challenged the award and we succeeded. What had happened in that case was that good that Mr. Ashok Sen was an eminent that he was, he obviously could not get along with the arbitrator, who was no other than Mr. Lauterpacht QC, Professor Lauterpacht QC of the Cambridge University. And we succeeded. And this was a case where there were transcripts, and it was clear that there was misunderstanding and continuous friction between the advocate Ashok Sen and the chairman of the tribunal, Sir Lauterpacht. And this is what Mr. Justice Habau set aside the award, and this is what he said, which is good to note. In his judgment, the judge ticked off Sir Lauterpacht QC with the following words. However, the function, and it's good for all of us to remember, all of us who are arbitrators. However, the function of any tribunal is to separate the wheat from the chaff and endeavor to arrive at a fair and just conclusion, notwithstanding the lack of assistance they may be getting from one or more of his party representative. Now, this is very important because very often the arbitrators are very technical and they simply sort of go by what arguments are before him, but they have a duty to do justice and always keep in mind that law is for justice and not justice for law. The other interesting case is the Indian Oil versus Coastal Bermuda. Now, this is a classic case. What is the remedy, if any, when the arbitrator decides against the party, but he says that the party who lost, the legal team was incompetent? Now, that's quite a serious thing, and no arbitrator would usually say that. But this was a case called the Indian Oil versus Coastal Bermuda. Again, about $9 million, and three eminent arbitrators were appointed. I was not the lawyer. Indian Oil had not come to me before that. They went to Instant Company, a very, very big law firm. And the three arbitrators were Gordon Pollock QC, Adrian Hamilton QC, and Martin Moby QC. Two of them became judges later on. And the decision went against Indian Oil, but Mr. Gordon Pollock, look at his courage. And he was not Indian Oil appointed arbitrator. He says at the end, I wish to record my regret that Indian Oil had not at some stage broadened the scope of the case. The documents gave rise to a strong indication that the buyers had intended to create a clear impression in the minds of the seller that if a satisfactory settlement of demurrage claim were made, nothing further would be heard by the enormous losses said to have been suffered by them. And the claim was for enormous losses. In the result, I believe the seller had a far stronger case than they allowed themselves to advance, one of which might well have succeeded had it been formulated differently. That's a very unusual case. The arbitrators decided against. There was an agreement not to appeal. And in Arbitration Act 79, there was you could appeal, and this would be a final decision. So they came to me, and Mr. Ramachandran, who was the legal advisor and later on became the chairman of IOC, said, we don't mind if the award went against us, but our heads are going to be chopped off in Delhi because the arbitrator said that Indian Oil's legal team was not competent. And in fact, there was an eminent solicitor's firm in Bombay was also taken. I went to the council. The councils, I gave a particular way of public policy interview. The council said, this is quite ridiculous. You can't do anything. You're bound by it. So I took a completely different point, and I do cases myself without going to barristers. And I took to the issue that this would be, if the award should be set aside, although it's the final award and you can't appeal or challenge it, on the grounds that it would be against the British court's public policy to allow the award to be enforced, on the basis that the arbitrator has himself admitted that had the case had been formulated in a different way, the result would have been different. So it is not based on the true legal analysis of the evidence. We went and we succeeded. And this is a very classic case of you can challenge the need to have a supervision in the interest of justice. In his judgment, allowing the award to be set aside or remitted, Mr. Justice Evans, he referred to an old Indian case called Ras Bihari Lal versus the King Emperor, which was 1933, and he said the finality is a good thing, but justice is better. And this is very, very, very important to remember. Finality is a good thing and justice is better. One of the beauty about London being an international arbitration, that the arbitrators focus more on doing justice and common sense. I'm going to give you one other Indian case, which is of utmost importance and became, very few people know about it, but it was because of the judgment in that case that Russia succeeded in challenging the award of UCOS of $50 billion. And that was a case called PC, only a few years ago, 5 or 6 years ago. A PC Limited, a wholly owned Indian government company, was facing a claim of some $8 or $9 million from a rice company in Thailand called Asia Golden Rice. It was a GAFTA arbitration. Now, grade and fee trade arbitration, lawyers are not allowed. It's a trade arbitration. Lawyers can make written submissions, but then they can't appear in court. They can't even sit in the court unless special permission is given, which is now not given. PEC, the Indian government company, lost. There was an award of about $9 million. There's an appeal provision. Again, in the appeal, lawyers are not allowed. There must be a trade representative who appears and argues. They lost. They came to me and they said, look, please do something. This is quite a large amount for India to pay, and what to do. Now, there was no answer to that because it was a GAFTA award, final award, and the GAFTA rules are that you can't challenge the appeal award, and so that was it. So the important thing to be innovative and creative, and today people from all over the world come to my firm because we are known to be creative and innovative to find a solution to do justice. Fortunately, because of my experience with the Indian government, and this is very important how it turns out to the UCOS, the Russian case, I knew as an Indian government solicitor that there are government rules for signing of contracts on behalf of the government. And therefore, a government company requires two signatures, the chairman and a director, and not the chairman alone. And I found that only the chairman has signed the contract, and therefore I took the challenge, Section 67 application, that there was no arbitration agreement, even though parties had fought in the arbitration for 3 years, and therefore the award was a nullity. It was considered an absurd point. I remember I was in Iran. I instructed for hearing Michael Brindle QC and eminent counsel, and we were in Iran on a Bank Malat case together. And the guy says, Sarosh, do you remember? Please note that there's not even 1% chance of succeeding with this claim because there's such an uncommercial point to take. The matter came up before Mr. Justice Andrew Smith. My argument was that because the contract was entered on the soil of the Republic of India, although the contract provides for English law and English jurisdiction, contract to be governed by English law, the actual conclusion of the contract has to be in accordance with the Indian law. And because the Indian law was not followed correctly, the contract was invalid and a nullity. I brought as my expert Soli Sorabji, the former Attorney General of India. The other side brought Harish Salve as their expert on Indian law. They both were cross-examined before Mr. Justice Andrew Smith. And the High Court judge said, that is correct. There was no contract because the formation of the contract would be governed by Indian law, although the contract itself was to be governed by English law and the arbitration under English law. Now, this is quite interesting because 2 years later, Russian Federation, with whom I was in contact because of the Bank Malat case and the sanctions on Crimea, they came to my advice. they had an award of $50 billion against it, which is still going on because there's an appeal now in the Supreme Court. And they had an award, and they didn't know what to do. They went to the top American and English law firm. They said, you can't do anything. You participate for 5 years. It was the investment treaty arbitration. They came to me. I said, look, English court doesn't have jurisdiction. Please advise us what point to take. So they asked me to appoint a lawyer, and I appointed Professor Vandenberg. And I took that point, and Professor Vandenberg's first reaction was that this is quite a technical point. It's absurd. You have participated in the arbitration, and you can't now say there was no arbitration agreement. But he took it. And as you know, it was in a news item all over. We succeeded on the basis that although the Prime Minister of Russian Federation had signed the investment treaty, the Russian law required it to be ratified by the Russian parliament, and this was not done. And therefore, the investment treaty had never come into existence, and there was no arbitration agreement. And that happened last, I think 16 months ago. 2 months ago, the Dutch appeal court has overruled the decision, declared the award to be valid, but now it is before the Dutch Supreme Court. So what I'm trying to stress is that by creative and to do justice, because 50 billion is an absurd to give it to the UCOS, who himself was probably a crook, they all sort of stolen money. But you have to be creative and to be fair to everybody. The other classical case, which I will never forget, were a chain of cases which went on for many, many, many years. When India was chartering the ships, there was always congestion at the Indian ports. And the classical issue was, there was a charter party term which said the notice of readiness can be given when the vessel is entered at customs and entered at port. Now, what is meant by entry? Now, that was the issue. The arbitrators took a commercial view, and there were two judgments that as soon as the vessel comes within the port limit, and there were two entries, prior entry and the final entry. And the prior entry could be given by the vessel's agent even before the vessel had entered. And therefore, the question was, when does the daytime commence? And the arbitrators all over said, it commences as soon as the prior entry is given, because that's been my entry. There were about $10 million at stake. And this was the case when my book was launched in Delhi. One of the senior retired chairman of the Food Corporation got up and said, I remember those cases, you saved us money. And I was very pleased to hear that. So again, I took the point and there was a judgment of Mr. Justice Bingham and Mr. Justice Lloyd saying that Food Corporation's argument was so bad, they should be twisted at birth. So when they came to me, and this is the truth, I've said in my book, and I took the view that the Indian law applies, although the contract was to be governed by English law and English arbitration, and the Dicey and Morris principle of conflict of law, the place where the contract was to be performed, that law would govern. And under Indian law, the entry at customs would be the final entry when the customs authorities give permission for the goods to discharge. So I said, let's start under arbitration. There were two judgments very bad against us, Mr. Justice Lloyd. So I appeared myself. In arbitrations, I normally appeared myself. And that was a good experience for me because when I acted for Indian government, there was a foreign exchange crisis, and it was not easy to get sanctions from Delhi to instruct barrister to pay in foreign exchange. So I used to appear myself. I appeared before the arbitrators, 3 arbitrators, and I raised a point disagreeing with the judgment of Mr. Justice Bingham and Mr. Justice Lloyd. And the arbitrator, there was slight racism there also. One of the chairman lost his temper, and he said, Mr. Zaiwala, you are insulting our judiciary, and you are not following the judiciary. And I said, no, please hear me out. This is true incident. And I put it in my book and I had it approved. And he got angry and said, no, you must listen to me first, sir. And then you can decide against me, but you can't stop me. So he said, no, I'm not going to tolerate your insult to our judiciary. And he walked out and he resigned. And there was a panic, but I stayed cool because I knew that in those days it was different. I was the first Indian around there. So they're going to say, as it is, I'm used to people criticizing me and saying ill about me in the white circle. So I stayed quiet. 6 weeks later, the new chairman was appointed, Michael Dean QC. He was much better. He listened to me. He said, Mr. Zaiwala, I understand your point, but our hands are tied because of 2 judgments. I said, fine, give the reasons, because there were reasons. Award came against us. went before Mr. Justice Webster, we won. And Mr. Justice Webster said, I think that now the way the case is presented, Indian law would apply, and it will be the entry at customs would be the final entry when the customs gives permission for the goods to be discharged. So all the P&I clubs are the ones who have legal fees insurance cover for all shipping cases. And they are the sort of the boss and who to appoint as lawyers and everything for all shipping. All ship owners have a P&I cover, professional and indemnity cover to pay legal fees, insurance cover. So there was another vessel called Nestor. Again, the same thing happened. So I said, I went up again. Mr. Justice Webster was not a very well-known judge. And again, the award went against us. And it was challenged by me. And it came before Mr. Justice Leggett, who is no more, but his son is now Lord Justice. And we won. And he said, I'm agreeing with us, not because of committee, because Webster had given the judgment, but because of inclination. Now, lo and behold, Homan, Fenwick and Willen, the well-known maritime law firm, appealed the decision. And then the appeal came before Lord Justice Bingham, who by that time had become Lord Justice. And I said, my God, the same judge said this is a hopeless point. We've got no chance of winning. But look at the fairness of the British judges. He made it an inter-party hearing. It was and after hearing both sides, he said that the way now the case is presented, I'm bound to say that my earlier decision was wrong. And a week later, I had a call from Lord Wilberforce, one of the finest or the best known Lord Justice, House of Lords judge, telling me, is it true that Lord Justice Bingham said one of his earlier judgments was wrong? And I said, yes. He said, can you send me the judgment? And then he sent me a letter, which I prize very much. He said he paid great tribute to Lord Justice Bingham and myself for skillfully producing the right argument. So this is the advantage of supervision. Now I'm going to tell you about some experience about China. I was fortunate that I was picked up by China. What had happened was we were acting for Indian High Commission, and it was the greatest experience. And I must be honest, my firm was made by Indian High Commission. And it was the amount of cases which we had and the support I had was enormous. And I can also say with confidence that in my many years of experience, about 14 years of acting for Indian High Commission, I never came across a corrupt official. And I found, especially Ministry of Shipping and Transport in Agro-India, I'm talking about the 90s, 80s and the 90s, they were all completely committed to the job. There was one possible slight, but otherwise I found that they were first-class civil service we had. I hope it continues now. What happened was that when we started acting for Bachchans in the Bofors in 92, 93, and Kuldeep Nair became the High Commissioner, and he was obviously against the Congress Party in those days. And he called me, a very nice man, and he invited me for tea, and he said, look, why are you acting for these rogues and rascals? And then he had a nice chat, and he finally gave me a warning. He gave me 7 days to decide whether I'm going to act for Bachchans or the Indian High Commission. And I told him, like a typical Parsi, I said, there is no conflict of interest because the Bachchans are suing a foreign newspaper to clear their name. No conflict with the Indian government. So I said no. And this resulted that I was sacked in 76 cases by just one email not to act for Indian High Commission anymore. But see how fortunes turn. Just 2 or 3 weeks later, I was at a lunch at the House of Law. Somebody had an event, and somehow the Chinese ambassador was on the table with me. And he said, oh, I've heard about you. And we started talking about China. And he said, why don't you visit China? And I will be my host. And I thought it was not serious, but he invited me for lunch at the Chinese embassy. And December 1991, I landed up in Beijing, a completely different China. I've said this in my book. And I spent 1 week. The Chinese government paid my hotel, my accommodation, only the flight was paid by me. It was the most fascinating experience I had. And I found that China was very keen to learn that how an Indian could start a law firm in England. And he wanted my advice on what we should do to bring foreign investment into China and how to bring about foreign firms. And that gave me, soon thereafter, I became the lawyer for all Chinese cases, in arbitration cases. And it was a great experience for me to do a case called, which is all reported cases. And in my books, they are there, called China Petroleum Engineering Corporation, and concerning a Kuwait construction of a gathering station in Kuwait. And that was a fascinating experience. And the best case I had for China was LG Caltex versus China National Petroleum Corporation. Now, this case had also adverse reaction on China because the issue was, we took the issue of jurisdiction, whether again, the same issue of whether the contract was signed or not, because when you don't have defense, you normally go on a technical point. And we took the point that the contract had not come into existence. The contract contained arbitration clause, London arbitration clause, because in the Chinese law, a contract is not concluded, not when it is signed, but when the company's seal is put in. And after 2 weeks of arbitration, the interpretation, we won. And Bruce Harris, the arbitrator, said he had no jurisdiction. So the other side, LG Caltex, the Korean company, appealed. It was a $350 million claim against us. It was concerning construction of a gas gathering station in Maoming in China. And what an experience it was to travel all over China and act for China. And I found that the Chinese respected India. That's another story I will tell you in a minute. And we won. And the other side appealed again. LG Caltex appealed in the Court of Appeal. And the Court of Appeal judges, very eminent tribunal, Nicholas Phillips, Bernard Riggs, found that the arbitrator and the judges got it wrong and that it had jurisdiction. So what then happened was that the whole arbitration had to start all over again because the 2 weeks was 2 weeks hearing in the arbitration was only on the issue of jurisdiction. Now, as a result, the Chinese got quite upset with the English arbitration, and they have now gone back to Sweden. But it was a great experience to actually work for China, and we did lots and lots of work for Chinese shipping company, and we are still very close, friendly to China. One of the things which I found with China, that this is one of the only countries where China respects an Indian more than a white man. And in fact, Chinese word for a white man is devil. And I found that wherever I went, everybody says Indu, 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 and they liked me. So these are the few cases which I wanted to share with you. There are many more if you want to do, but tell me what is the time. I don't have a clock with me, and I can now answer questions.
Sir,
unless you want me to go on.
You have been in session for about 33 minutes now. If you want, you can go ahead, sir. No issues, sir. We can take the questions later also.
Okay, I will certainly go on. And I'm going to share my experience of starting in a foreign country, because I think our Indian brains are compatible and can compete with any other as far as intelligence is concerned. But if I'm honest as a fellow Indian, what we need is intellectual discipline. I think that is where we sometimes lack. Whereas in the West, everybody has a discipline and a sense of duty to do one's best and nothing else. And that is what really matters. And therefore, one of the reasons why I was asked on a UK television, what is the secret of your success? And my answer was Indianness, that I kept my Indian name, I kept my Indian accent. Before I started, there were solicitors, law firms started by East African Indian and Pakistanis, but they were in the ghettos doing immigration and crime. And they had all anglicized their name. They changed their name into English name, but there'll be Indian face later on. So I decided to start in the city of London, keeping my name Zaiwala. And the judges couldn't pronounce it. I know many of the judges had problems mentioning my name, but today we are quite well known. As Mr. Ravanan said, we launched the first ever challenge against the nuclear sanctions. And that was a case which came to me. Bank Millat is Iran's biggest private bank, 20% owned by the government. And Bank Millat was constituted when the 79 revolution, when all the private banks were nationalized and became one Bank Millat. And Bank Millat was listed under the UN and not under the UN, US and EU sanctions for allegedly supporting Iran's nuclear proliferation. They challenged it. They said, we have got only 20% interest of government and we are a private bank. It was one of only Iranian international bank. And they had offices in London, Germany, everywhere. And virtually the offices had to shut because nobody would treat them. So they went to a big firm, Stephens and Harwood. They challenged the sanctions. They lost in the High Court. They lost in the Court of Appeal. Then, hello.
So you're audible. You're audible. You can go ahead,
I'm
sir.
on?
Yeah, you're on. Very much on.
Okay, that's fine. Okay. So then they came to me. They said, we want to change solicitors. They came to me. And that's the other story which I'll tell you later. And we decided to take it on to the Supreme Court. Now, Supreme Court bench is only 5-0. When I was in Iran, the chairman of the Bank Mellat over lunch, and my counsel, Michael Brindle, the Queen's Counsel, was with me. He said, Mr. Zaiwala, Britain is the beacon of justice. And I am not told what is the evidence against me that I am supporting Iran's nuclear proliferation. And there is a provision for terrorism cases, because considered as part of the terrorism, so there's a secret court. So I wrote, and this is something I always do, I wrote a personal letter to the head of the Supreme Court, Lord Neuberger, who of course has known me. And I told him with a copy to the other side, the government, Her Majesty's Treasury, which is the defendant. And I said that I was at lunch, and this is what the Professor Divandari, he was brought in as a chairman to privatize the bank, and he was specializing in privatization. And he said that Britain is a beacon of justice, and he doesn't know, and because of the secret court procedure. See the informality. 2 days later, I got a telephone call from Lord Deputy Chief Justice of the Supreme Court. He said, Lord Neuberger, the President has got your letter. He's considering it seriously. You'll hear about it. A week later, the registrar said the Supreme Court has taken a decision that they're going to vacate the hearing and fix a new listing, not before 5, but before 7. Ultimately, it was listed before 9 judges, and we won 5-4. If I hadn't written that letter, I don't know what the judgments would have been. But the Supreme Court had the courage to say that the UK government had acted unlawfully and also irrationally in sanctioning, in listing Bank Mellat. And then we had a claim against the UK government of $4.2 billion in damages, but it was reduced to a realistic figure of $1.6 billion. And it went on for 7 years. They fought hard and there. And ultimately, we settled the day of the hearing for a 9-figure sum. And then the real issue was the Iranian bank said to Mr. Sarosh, you know, nothing is going to come of it, because even if we succeed, they won't pay. What can you do? And we got a judgment by consent. But how do you enforce the judgment against the crown? Do you take it to Buckingham Palace to say, please give me the money? And that was a big issue. Now, there again, the last date for payment was 31st July 2019. Date came and went, no reply. We wrote to the HMT, what can you do? You can't go to how do you enforce a judgment against the crown, Her Majesty's Treasury? So then I came up with an idea, not entirely my idea, my colleague's idea, that there was evidence that the UK Parliament had passed a bill to pay this claim. So it was not because of lack of cash, because that would be a ground for not paying if somebody doesn't have the money, because you go bankrupt, but you can't make the government bankrupt. So we came up with the idea that why don't we go for contempt of court against the Chancellor of the Exchequer, which is the Foreign Minister, and possibly even the Prime Minister, because he takes the ultimate decision. And I didn't go to my barrister and said, no, don't do this. But I wrote a letter to the Judge Javid, was the Chancellor of the Exchequer. And I said, if you don't pay within the 7 days, then you are in contempt of court to be sent in prison, to be arrested and sent in prison. And please copy this letter to the Prime Minister too. And believe it or not, in 7 days, the payment was made 4 weeks late, but it was paid to Turkey. So sometimes you have to be bold and take a decision. And this is what I always say, that the secret of success is also being honest and integrity, but having a courage, a quiet courage to take decisions and take unusual way of doing it in the interest of justice. Now, just now the Venezuelans have come to me. They also went to some other law firms. Everybody said, oh, you can't fight the Bank of England. But we did it. And yesterday, all over the world, it has created such a news item. All the newspapers, BBC, everybody is full of the news thing. We are suing Bank of England because Bank of England, and under a contract, provides a service for safekeeping of golds of sovereign nation. And Venezuela had given the gold 4 years ago. The same people who signed the contract from Venezuelan Central Bank wanted back. They said, we don't recognize it. So we're having fun and game. Yesterday, there was a hearing for expedition because there is COVID crisis in Venezuela. They don't have money. They need the money. President Trump has said to United Nations not to help, but we've got UNDP to help. So we take over. And this is where I said that what we Indians need to do now in the legal field, in the arbitration field, is to not to dominate, but to put our Indian footprint on the globalization of the legal market and the arbitration market. Speaking very briefly, just to the point of arbitration, people ask me time and again, what do you think of the future of international arbitration in India? And I say, why not? The future should be there. But we must understand and recognize our shortcomings. And our shortcoming is you can't blame the government and you can't look to the parliament to say, make the law. The change which we require to make us competitive in the international field must come from within. The lawyers must come from within. For example, there's a suggestion that some of the arbitrators are corrupt. I don't know whether it's true or not. But in England, if any arbitrator was even slightly suspected of fraud, nobody will invite him anywhere. He will be completely blacklisted. And that is why the standards have remained. So the change must come from within all of us to ensure that. I'll give you one example of, I was sitting as an arbitrator about 6 or 7 years ago in Bombay with Harish Salve. It was, I think, concerning a power plant in Karnataka, in Jindal power plant in Karnataka. And we appointed the chairman. I insisted in appointing a Court of Appeal judge, Sir Anthony Evans, who also gave a judgment in the other case where I was involved. And it was a 2 weeks arbitration, Mullah on one side and Amar Chand on the other side. And on the third day or fourth day, Harish Salve said, Sarosh, I can't attend tomorrow. I'm sure Anthony Evans would not mind if you take a day off. And I said, you speak to him. And he spoke to my chairman. And the chairman said, no, you can't go. Because we have fixed the arbitration hearing. It doesn't matter who has called you. You should have told the Lord Chief Justice of India. And he was saying, no, I have to make a mention. The Chief Justice has personally requested me to appear to mention about some Delhi airport case it was. And he said no. And Harish was sweating. He said, what to do? He said, no, the hearing will come on. Your seat will remain empty. It will go on. Ultimately, Sir Anthony Evans relented. And he says, I've got to mention at 10:30. I can take the 1 o'clock flight and be at 3:30 by 4 o'clock. So we allowed him to go. But Anthony Evans said, okay, in that case, we will sit from 4:30 to 10:30. And we did sit from 4:30 to 9:30. And we finished the arbitration. Now, this comes from within. Now, if you tolerate the arbitrators adjourning the hearing and earning fees, then it is not the arbitrators who is to be blamed, but the parties are to be blamed. The lawyers who allowed this to be blamed. We are in England quite firm about this. And in England, if a case is listed and if a lawyer is not available, bad luck for him. Even in court, he has to be present. And I've known of cases where a lawyer was suspended for 3 months because he had taken double booking in a court case. Now, that is not allowed. Now, finally, I would like to say that and as a fellow Indian, I would like to say that we have to get over the big handicap that we were ruled by British, and what we have in India, whether we like it or not, is the colonial imperialistic system of judiciary. Remember, 4,500 white civil servants were ruling 450 million until they left. And therefore, the small community had to keep the high and mighty stature of them and keep the local Indian at away. Therefore, I find that in the legal system, everything is slow, because that's what the British wanted to be slow. In England, it is very, very relaxed. If you have a pleading of more than 20 pages, the judge says, I don't want to listen, just tell me what are the points. And the justice is done. So we have a system where what happened was when the British 4,500, the upmarket superman went away, the Indians who went into the place became the Brown Sahibs and then continued the system. We need to make it a much more informal, much more realistic legal system. Adjournments will not be allowed. Long affidavit and witness statement are not allowed. When we were sitting in, and I sit in India quite often, and I was just having taken this particular case with Anthony Evans and Halvey, every evening we used to get files of documents. To be honest, none of us ever read it. We had the experience to know what the truth is, and we can judge for ourselves what it is. So that is something which the Indian legal fraternity and the Indian commercial fraternity needs to act to change, and not to look to the government and the parliament. The parliament can pass as many laws as they like, but it is how it is implemented that matters, and how the lawyers' legal fraternity cooperates. And I think India has a very big future. I'm sure that the next generation is this century is for India, especially now with the Chinese COVID. And we must realistically, and very realistically, look back and look at our faults also, and look at our shortcomings, compare it to what is required, and then try and incorporate changes without too much noise. Thank you. 45 minutes?
Yeah, that's 45 minutes almost. We have some questions. One, Mr. Vakil wants to ask a question. I'll unmute him so that he can ask. Mr. Vakil, you are unmuted. You can ask.
What's his first
Thank
name?
you. Hormuz there. Hi, Sarosh.
Hi, Hormuz.
This
Hormuz,
yeah. I have a couple of questions. Would you
Certainly.
appear for the Chinese government today?
Yes, I would appear for the Chinese government because they have been my former client. And as far as I know the China, the legal system, I was involved in that, so I would appear for it. But I wouldn't appear if it was against India, because there would be a conflict. But Chinese commercial cases, of course, I would appear. I've appeared for many Chinese commercial cases. But I don't think they will come to me now, because now I had an office in China until 2004. And the only reason why to shut it down, because now they have 1 billion Chinese lawyers, and they would naturally prefer to go to the Chinese and not to come to me. So we have good relations, but I can't say I have very good relations now, because after my involvement with Dalai Lama, trying to facilitate dialogue, Chinese are friendly, but they are quite cold towards me now. Answer?
No, considering their global position in the world with all this COVID, would you think it would be conscionable on your part to appear for the Chinese government?
If it is a commercial case, yes. As far as I certainly have my concerns about the Chinese involvement in COVID, and I hope that there will be investigation. And it's my personal view, and not a very fully considered view, that China has some responsibility, even if it was, which I have no evidence to say that, if it was a virus which was man-made virus. But I have some concern, because this is the third or the fourth epidemic, the SARS, the MERS, and various things, the chicken disease and all the thing. So China have a responsibility to the world. And I think the answer to that is that what we need to do is the world countries must come together and tell China that enough is enough. And we want inspection of their facility for this biological weapons in Wuhan. So that's my answer. As far as commercial cases are concerned.
So you would compromise your. So you
Mr.
would
Vakil,
compromise.
Mr. Vakil, I think the speaker has answered.
All right, all right.
Thank you.
I'm talking.
Okay, next question.
One, Mr. Lennon, he's got a question. Mr. Lennon, you have been unmuted. You can ask.
Good evening, Mr. Sarosh. I picked up your book.
What a name you have.
My name is Lennon.
Yes.
Hi, good evening,
yes,
sir.
Go on. Good evening to you.
Thank you for such a very insightful session. I picked up your book sometime 3 months back, and I got a chance to read it during this COVID-19 lockdown. It was a beautifully written book for a person like me who really aspire to become a commercial arbitrator. Having said that, Mr. Sarosh, I have worked for top IT commercial companies in India as a commercial lawyer. I was just planning to shift myself to the UK, and either I need to join the commercial team in any IT firms, or I should start a practice of my own. This is what I think. What would be your advice on that, Mr. Sarosh?
First of all, in order to practice as a commercial lawyer, you have to qualify as a solicitor or barrister in UK. So I'm sure that you can qualify that. There are ways and means to do that. The way to start is really, if you start on your own, it's not so easy. So therefore, you have to join somebody who has a practice already and become an assistant. And like every other profession, you sort of learn on the job and you make contacts and take it up from there.
Okay. Thank you. Thanks for that, Sarosh.
We have some questions on the chat panel. Mr. Saranan has a question. This is with respect to the multiple appointment of arbitrators. with respect to the 7-bench judgment bench case, which is pending before the UK Supreme Court on Halliburton Co. versus Chubb Bermuda Insurance aspect. What do you think would be the outcome of that case, and what is your opinion with respect to the multiple appointment of arbitrators?
See, I can't, of course, predict what the Supreme Court will do. The Supreme Court is extremely independent. But Supreme Court will find a way that all the arbitrators sit together for one hearing in a practical sense. And that way, the multiple arbitration, if the same issue is involved and there are different tribunals, it is better to sit together.
No, here the query was with respect to the same arbitrator being appointed in multiple cases. That was.
I got that.
Yeah.
That is an old chestnut, and that has historically been always there in England. But in England, the general belief, I'm talking about in the past, when I started, was that the arbitrators are honest. So therefore, they will decide independently. But the fact of the matter is that in actual practice, if he has decided one way in one case, then what happens? He might be inclined to decide the same way, unless somebody like Mr. Lord Justice Bingham, who said he was wrong. So I think that's something we need to look into. It comes to my mind that we had a case for an Indian client, ASM Ship Management Company of Bombay, versus an American company. It was a shipping case. And whilst the arbitration hearing was going on, and my ship broker was giving evidence, the chairman was a QC. It's a reported judgment again. Chairman was a QC, asked him some question. And to everybody's surprise, the ship broker, Mr. Mustaka, said, "Why are you asking me this? You know about it. You were involved." I didn't know. I couldn't understand what he meant by it, because he was a Greek shipbroker. Some of them are quite crazy and they speak anything they like. But then there was a tea into it, and after that he said he wants to announce that he had advised indirectly the other side on this issue and had one meeting, but he's completely independent. He's the Queen's Counsel. And do we object? So I phoned up my client, who was an Indian ship owner in London and a very, very well-known personality. And he said, "No, I object." So now under the Arbitration Act 1996, if you are going to object, you have to make an immediate application within 7 days. Yes. I asked him, and I said, "How much will it cost?" I said, "It costs about 30,000, 40,000 pounds. He said, "No, I don't want to object." So we lost. The arbitration went on, we lost, and we challenged. And it came before Mr. Justice Morrison, and he said that the third arbitrator, the QC, had misconducted himself, and he should not have said. But because there was no objection, the award stands. And he used the phrase that you can't take heads I win and tails you lose. Now, to answer your question of multiple, I'm aware of that. It's a very difficult, and I certainly think that is wrong, because the human mind always remembers and recollects what has been decided. But then it comes into a larger question that although we are in India sometimes very puritanical, I found when I was at the International Court of Arbitration representing India on the ICC code, there was some slight lobbying also going on. I wouldn't name any country or person. So therefore, one has to be very careful that independence is maintained. And therefore, I would be against it. And at least he must make a full and complete disclosure of his decision. And then if the parties are consent, that's fine. But otherwise, he should not.
Thank you, sir. Mr. Murali Mohan and Ms. Reshmi Bothra, they both asked for citations of the case. I think you had referred mostly arbitration matters, which are confidential and they would not have been published. Your views on that?
All the cases I preferred are published.
Published, is it? Then they would like to have the citations, sir. If you can provide to us later, we can give it.
Which case? Which case?
There were several cases that, in fact, you had.
Yeah, all the citations are all in my book.
Okay.
All in my book. They can get my book and they find all the citations.
Okay. So if you want the citations, they're all in the book. You have to purchase one, and then you can have the citations there. Saravanan has got one more question. There is a saying in Tamil, instead of playing a king role in a foreign soil, it is better to play a minister's role in your own soil. You're a successful lawyer in UK. Have you ever thought that you should have practiced in India?
I've certainly intended to come back to India, but I'm very content that I have been able to bring about Indian footprint in the international arbitration market. So therefore, sometime, and I consider myself a foot soldier. I don't want to be a king.
Mr. Vakil has again asked one more question. Can you please elaborate further on intellectual discipline mentioned by you earlier? Will you fight pro bono for Venezuela government? I think that's personal, Mr. Vakil. I don't know why.
No, but I am not fighting pro bono for Venezuelan government. They are paying our fees.
What would be the scope of online dispute resolution in future? This one is asked by Sarunan again.
I think this is going to come, and this is because when this lockdown came for all of us, I'm not in my office just now. I'm in my country house, and the court hearing takes place on the online, and is with video, and it goes on quite all right. We're getting quite used to it. So I think in future, the online arbitration is going to be the order of the day, because now it's nearly 3 months since we are in a lockdown. Online hearing is started. Everything is working quite all right, and I'm sure that if it goes on for another 2 or 3 months, people will get used to it, and it also saves time and is less costly.
Yeah. Mr. Siddharth Dawhale has one question. What book would you suggest that he should refer to start a career in international commercial arbitration?
The two books. One is the old ancient Russell on arbitration. The latest edition is that one to do commercial arbitration, and Russell has been going on for 50, 60 years now. And the other is Mustill and Boyd on commercial arbitration, and that is the latest edition. That's a very popular book. So like Mustill and Boyd is now the Bible along with Russell.
Here I need to say, to buy Russell's book, I think you should have won at least 2 international commercial arbitrations. And the other question is from Mrs. Rubia Tanija. She wants to thank you for sharing it. No, she has thanked for your sharing your experience. There's another question. What are the criteria to be an arbitrator in UK?
Arbitration agreement is by consent. So anybody can be an arbitrator if you are independent and you're appointed by the party. But to hold yourself out as an arbitrator, you must have a good reputation. You must have some qualification. Historically, arbitrators, even in England, were not lawyers. They were traders. And arbitration started 300 or 400 years ago in the Baltic Exchange, where the ship broking used to take place, and if there was a dispute between the brokers, they would go to one of the senior brokers, sit with him, and he will decide, and his decision will be binding. So anybody can technically be an arbitrator, but he must have the standing to be the arbitrator.
Yeah. Again, Ms. Rubia Tanija has got another query. She wants to know how you can be contacted for seeking advice on arbitration law. I think your website, Zaiwala, just go to Google, madam, and type his name.
Contact me, sir.
It's available.
Yeah.
There's another question from Mr. Chokalingam Radhakrishnan. Inspiring arbitrator. India is known for panchayat and arbitrations, but the stress of intellectual discipline may be explained.
What is the question? In stress?
The stress for intellectual discipline. You had spoken about intellectual discipline. He wants to know more about it.
Yeah. Intellectual discipline is the need to be completely honest and working with integrity and fair. That is the intellectual discipline. Not keeping any personal interests of whatsoever. Personal likes or dislikes are also not there. When I decide the arbitration, when I sit as an arbitrator, the thing which I do is to do what I call justice. I was sitting in Israel for 2 weeks on a family dispute, huge family dispute between a father and a son, and the stepmother was involved. And at the end of the day, with all this evidence, I decided what I thought was fair and just in all the circumstances. And that is part of intellectual discipline.
That's a good example, sir. Sir, Mr. Siddharth has got another question. He says, can an Indian qualified lawyer seek to be an assistant without being qualified as a solicitor or barrister in UK?
He can, provided he gets a work permit. He gets licensed from the Home Office on an Indian passport to work. There are criteria, and it's not easy to get a license. He must find an employer who has a lot of Indian connection and who applies for a license.
Yes. Mr. Shreyas Basu Dasgupta has got a question. What are your views as to the economic state of Venezuela, and how will the gold which is being redeemed by the Venezuela government going to benefit Venezuela in short term and the long term?
Very good question. This is all in the news items. So read Financial Times, read CNN, look at CNN and Sky TV and other things. I think the answer is that there are two contenders to the goal. It's a very unusual situation. There is an elected government president who is, I forgot his name now, he's the one, and then Maduro. And then there is a president appointed by President Trump, who is called Mr. Guaido. And the question is, who is the right president of Venezuela? And in order to avoid this controversy, what we have done is that the present government has gotten agreement with United Nations Development Program that the gold will be sold and the proceeds will go not to the government of Venezuela, but to UNDP, who will in turn use in consultation with the government for the benefit of the people because of the COVID pandemic.
Okay. Mrs. Taneja has got another question. Would you represent India to, when you represent India, do you refer to the Arbitration Act 1996? Whenever the case permits, you'll have to, isn't it?
Of course, of course.
Mr. Thakkar has got a question. What has been your experience with med-arbitration clause? Have you seen disputes getting settled in mediation? Would you use it for your clients?
Of course, mediation is in fact I see more future in mediation than arbitration. And I will give you the example of the Bank Mellat versus Her Majesty's Treasury. We were very concerned about the trial, which is going to be a 6 weeks trial with 23 Iranian witnesses. And I wanted the case to be settled. And the UK government said, no, we're not settling, we're going to fight. And we applied to the judge for an order. And it was opposed by the Her Majesty's Treasury. And the judge ordered compulsory mediation, and we settled it after 7 days of mediation. And I'm a qualified mediator, and the statistics shows that when there's a mediation, 80 to 90% of the cases are settled at the mediation or within 2 or 3 weeks after the mediation. And from the balance 20%, I think 50% are settled before the trial. So I think mediation is very good. There are different kinds of med arbitration thing. You can have compulsory mediation, which is also not a bad idea, or you can have a specialist expert giving an opinion, which is not binding to the party.
There's another question from Mr. Shahid Basu. Sir, isn't this move being blocked? I don't know. I think he's asking about the Peninsula's thing issue. Isn't this move blocking? Being blocked by the United States of America, given that United States exercises significant influence over the UNDP?
And I think so far the UNDP has shown is quite independent. It is correct that the decision to sort of sanction Venezuela is being taken by President Trump, and the UK government is supported, and 66 countries are supported. The issue here is also of constitutional international law, that can another government interfere in the affairs of a sovereign state on the grounds that the elections were rigged and there was corruption. Now, even in the Indian election, there was an allegation of rigging or thing, but that doesn't mean that it was rigged. And can British government say, now I do not recognize your prime minister, I'm going to put somebody else. So this is the situation in Venezuela.
Mrs. Taneja has got another question. She's asking, how long does it take to get our international arbitration award enforceable? I think she's asking for the period in which Indian arbitration awards, domestic awards, they need to wait for 90 days. Her question is, in case of international awards, how many days it takes for it to become enforceable?
The answer is that because the arbitration is a creature of a contract, parties have impliedly agreed in the contract that as soon as the decision comes, they have to honor it. So therefore, really, there should be no need to enforce the award, and parties are obliged to pay the award. Unlike the court jurisdiction, which is a statutory jurisdiction, the arbitrators are creatures of contract. So therefore, parties have an obligation to honorably pay the award.
Yeah. Mr. Kalyaniwala has got a question. Limiting the scope of appeal in case of challenge of a foreign award in India may lead to injustice if a party thinks his case is not properly decided on merits. In your opinion, should the grounds of appeal be more open than what it is as per the amended arbitration laws?
I think when parties agree to arbitration, they recognize that they're going to be bound by the decision. It's a tribunal by consent. And I think as far as appeal is concerned, there should, in England, we have a procedure. If you're unhappy with the decisions on law only, not on facts,
Yes.
the arbitrator decides the facts you can't challenge, then you can apply under Section 69 for leave to appeal on paper. It is ex parte application. The other side gets a copy, they can comment. And unless the judge is satisfied that there's a very substantial question of law of public importance, leave to appeal will not be given. But there are issues where the leave to appeal is given and the award is set aside. Only one, and the decision of the court, High Court, cannot be appealed further. So there should not be more than one layer of appeal.
Mr. Thakkar has got a question. Do you believe that disputes arising from COVID affected contract should be compulsorily referred to mediation?
It's not a bad idea to not compulsorily, but make it mandatory that before it goes to court, there must be mediation. That is possible, because there are going to be many disputes relating to force majeure and supervening impossibility, Section 56 of the Indian Contract Act because of COVID. It's not an easy question to answer because you have to look at all the facts. So if this goes first to mediation, not a bad idea.
Mr. Daival, I think you're going to have more questions from Mr. Dasgupta on Peninsula than the court there where you're going to appear. He says, sir, is there a possibility of any legitimacy of Peninsula's election, which is a domestic issue, ever coming before the International Court of Justice in international law?
At present, there is no such move. Simple as that. But I am trying to convert this. In my interview yesterday on the Euro TV, I said that this is an international issue because there is an international law on how each country must behave with each other. And if suddenly one country decides that it can still interfere and into the affairs of another country and change the government, that's a dangerous precedent.
Yeah. I think we are finished with the questions. If anyone else has any question, kindly raise your hands. I can unmute you all.
One more question from Nancy Siobia.
Okay, sorry, I think I missed it. I'll just check it out one second. Yeah, Ms. Nancy has got one question. With the guidelines note released by the ICC court in the current COVID-19 situation on 9th April for arbitration, how do you see arbitration centers adopting this guidelines note worldwide and implementing them with their centers' rules?
I think this is common sense because each arbitration center will have its own rules. And therefore, accepting as a guidelines, there's nothing wrong, but you can't dictate to each center. Seneca will have its own rule on it. And COVID is an important issue because there are going to be lots and lots of dispute parties unable to perform the contract because of the COVID situation. But please keep in mind that frustration is not just COVID. There must be good other reasons too. The contract cannot be performed. And if it is to be performed, it has to be a different kind of contract. Good, finished?
Yeah.
Sir, one more question.
Yeah.
What is the role of mediator report in arbitration proceedings? It is question from Mr. Murali Mohan.
Yeah, sorry, I missed it.
Role of a mediator?
Mediator's report, role of mediator's report in the arbitration proceedings.
I don't think that is right for a mediator's report to be published, because people go to mediators for confidentiality, and therefore mediators report goes on the bounds is trying to prejudice the mind of the arbitrators. The arbitrators have to be independent with a clean mind.
Yeah. I think that's it. We have finished with the questions.
Thank you very much for inviting me.
Thank you. Thank you so much, sir. Thank you for your thing. You have given an elaborate
remember, I'm an Indian and I remain an Indian at heart.
lot of anecdotes.
When people ask me, where am I from? I said, I'm a citizen of the world, national of Britain and native of India.
That's nice. Thank you so much, sir. Thank you for all the participants for coming in and registering yourself and being present today. Thank you one and all. Thank you, sir.
Thank you. God bless.
Thank you, sir. Thank you.
A short next session.
The next section, participants, there's a next section which will be on coming Friday. The next Friday. 1 second.
Dr. Chandrika Subramanian.
Dr. Chandrika will be addressing us. She is a counsel from New South Wales, solicitor and barrister. She will be addressing on international commercial arbitration, the effects of culture. Thank you, Anand, for reminding me. I almost missed it. Thank you, one and all.